How's that sound, okay? Okay, thank you. Good morning, board members. Thank you for coming here. I'm Harry Fergerstrom. I'm one of the parties that joined in this contested case. Please bear with me. I'm a little bit ragtagged. I just had major surgery, so I'm kind of floating in and out, but I believe I'm together enough to present a proper thing. Okay, so first of all, one of the things I think that is very important to recognize here is that one of the major steps that has been avoided or not considered to be a reality is under the National Historic Preservation Act. That's the 106 process. This is not an option. This is a mandate. This is a historic preservation law. Mauna Kea is a historic preservation of a historic district, known historic district. That in itself is a failure that would make this permitting impossible to meet. Secondly, I want to make very clear that I was the only petitioner in this entire case that was denied to have a witness. The only petitioner. Now, this is very difficult because the purpose of a contested case is to allow the public to bring up information that has not been previously brought up before. And I had sat through this entire hearing, all 60-something days of it, 44 days of intense testimony without being given a chance to fairly represent myself. And that is a violation of my due process rights, even under the 5th and 14th Amendment of the Constitution. And so I have to say with very clearness that I object to everything that is being done here, and I take exception to it all, because I was not allowed to participate. I'm a member of this community. I have been fighting for Mauna Kea for the last 20 years, and to have to go through this entire process and not being given the right to present my case is illegal. It is wrong, and it has made it so you are going to be advancing without the information that I could have provided, which have been very, very necessary to make a correct judgment. I'd also like to say that in that rejection of my witness, which is William Chang, Professor William Chang for the University of Hawaii Law School, I'm sorry, I thought I heard somebody. Anyway, this is very important because it seems its entire process has been based on this claim that the United States, through a joint resolution, has the power to annex a foreign, independent, neutral nation state by a simple joint resolution of Congress, which it cannot do. It has not done so, even by United States constitutional matter. These things have to be taken in consideration. Along with that is the apology bill, which is U.S. Public Law 103-150, where the apology to the Hawaiian people from the United States for its conduct with the overthrow of the Hawaiian Kingdom has been brought forth. This apology has been recognized in the Hawaii Supreme Court 13 times already, acknowledging that the Hawaiians have unrelinquished claims to their sovereignty and to their national lands. And in spite of how many ways it's been tried to express to us, where it has been pushed on us continuously that the state of Hawaii owns and has title to the sum of Mauna Kea, it has no such thing, and it has absolutely no basis to make that stance whatsoever. And the reason why it is so important to have these kind of cases is so the whole root of the matter can be brought out. If you do not talk about how you get your authority, you cannot tell me that you are acting in an authoritative manner if you cannot justify and prove where that root of that authority comes from. Without that treaty of annexation that I keep speaking that we do not have, and that I could have brought proof, I had actually brought Professor William Chang on January 23rd to this hearing to testify and be cross-examined. It was only at that time that he was rejected. His testimony had been on file for over 4 months before we brought him up. He came up here on my expense, where everybody knew that, and he was rejected right here when he was standing here to be vetted, here to be challenged on anything that he brought forth, which would have brought much light to this contested case. The state, at best, even if we were to pretend that there was some kind of legal authority, like there was a treaty of annexation, at best these lands would be considered Crown and government lands under the Ceded Lands Trust. That, in fact, clarifies that it is not the state property, or do they have title to that. Okay, these are Hawaiian Kingdom government and national lands. We have heirs, even in this room, we have heirs to those lands. I am one of them. And so, again, without affording me the time to present my case in a logical and legal manner, like we are presuming to do, you have cut me off from my own trial. You have made me so I'm not even allowed to speak on my behalf of what I believe is true and necessary for you to make a conscious decision. So before I close down, I want to make sure I do this. I want to make an oral motion now for a stay of execution pending all appeals, because there are going to be appeals in this case. I would strongly suggest that you folks would take this very clearly and look at it and consider the fact that this contested case was not done properly. In fact, from a person who's been in these cases many, many times, it was really shoddy. I mean, when you have a hearings officer that controls the hearing like a tyrant, like a tyranny, where she makes all decisions, she makes all her own rules when she pleases, not when it's necessary. Like, she answers motions 3 or 4 months after the motion is made. Yeah, when I bring up things like I was dependent upon the mail for my copies, and then that would not even be taken into consideration. I would be getting mail when they were changing the new rule, which continually left me out, and the more I brought it up, the more left out I became. In fact, so much so I was even a mockery, where I was publicly admonished for giving bad information to this body. It's like, somebody give me an offer of proof that says that I even received these things before you accuse me of saying that I didn't get them, which they have not been able to do. You know, we're not talking about something small here. We're talking about some of the largest attorney firms in the state, along with the Attorney General's office. You folks know what you're doing. I believe that you are resting your position on the fact that we don't know enough about what we are doing to challenge how you are looking at this. And I dare say that you are well aware. You are very well aware, and for this to come through completely without further stoppage, because this is just the start of it. We're coming down to the fact that the real culprit in the room is the University of Hawaii, being supported by yourselves. And it becomes very questionable when you have a Department of the Attorney General who's supposed to help the people of the state that offers no help to us who are fighting for our rights. We are right holders, not just stakeholders. These are our traditions, these are our mounds, these are our histories, they have to be included. With that, I can only say to you that I trust that you will take this into consideration and take it deeply, because it is very embarrassing to go back to the Supreme Court with the same argument that you lost before, and to find out that you not only didn't do what you were told to do, but you did it even more recklessly than the first time. Thank you very much.